The first thing the zoning officer did wasn't look at my tractor. He looked at Marla Whitcomb's pool house. That surprised everyone standing there, especially Marla. Just 10 minutes earlier, she'd been pointing at my father's old red tractor like she'd finally caught a criminal. She told the officer it was an illegal eyesore, a zoning violation, and proof that I was lowering property values for the entire neighborhood. I didn't argue. I never had. I simply handed the officer a weathered county document and stepped back. The moment he finished reading it, everything changed. Neighbors who had been nodding along with Marla suddenly went quiet. The officer asked her one simple question. She couldn't answer it. An hour later, a bright red violation notice was hanging on her luxury pool house while my tractor sat exactly where it had been for decades. And that's when the real story began. Before we get into it, tell me where you're watching from and what time it is in your area. If you enjoy real property rights stories where paperwork beats power, consider subscribing so you don't miss what happened next. My name is Caleb Mercer, and until all this happened, I thought the biggest problem on my property was keeping weeds from taking over the back pasture. I lived on 5 acres just outside Franklin, Tennessee. My land sat beside a newer subdivision called Willow Ridge Estates. The neighborhood had stone entrance signs, manicured lawns, and one of those homeowners associations that seemed to have an opinion about everything. My property was different. It had been in my family for nearly 70 years. The old barn near the road was built by my grandfather. The workshop beside it belonged to my father. And parked beneath a metal lean-to was an old red Ford tractor that most people probably considered scrap metal. To me, it was something else entirely. My father taught me how to drive that tractor when I was 12 years old. After he passed away, I couldn't bring myself to sell it. Every dent, every patch of faded paint, every oil stain reminded me of weekends spent fixing fences and clearing fields with him. The tractor still ran. Not perfectly, but it ran. Most evenings, I'd sit on the porch with a cup of coffee and look out at that tractor, the same way some people look at family photographs. Then Marla Whitcomb arrived. At first, she seemed friendly enough. She introduced herself as president of the Willow Ridge HOA and welcomed me to what she called the greater community. I remember smiling and telling her I'd actually lived there longer than most of the houses in her subdivision. She didn't seem to appreciate that joke. Over the next few weeks, she kept finding reasons to stop by. First, it was a suggestion about repainting my barn. Then it was a comment about the fencing. After that, she began talking about appearances, property values, neighborhood standards. The conversations always circled back to the tractor. "You know," she said one afternoon while standing near my driveway, "people can see that thing from the main entrance road." I looked toward the tractor. It has been there for 30 years. "That doesn't make it attractive," I shrugged. "Neither does half the furniture people put on their porches." Her smile disappeared. That was the first time I saw the expression she'd later become famous for around the neighborhood. The look that said she wasn't hearing a person. She was seeing an obstacle. A few days later, I noticed something strange. Marla wasn't just looking at the tractor anymore. Whenever she visited, her eyes drifted beyond it, toward the old farm lane running along the edge of my property. The lane wasn't much to look at, just a gravel path leading behind the barn and toward a wooded section of land. But Marla seemed unusually interested in it. One afternoon, I caught her standing near the fence line staring directly at it. When she noticed me watching, she quickly looked away. That's when I realized something important. The tractor wasn't the real target. It was simply standing in front of something Marla wanted. I just didn't know what that was yet. The first letter arrived on a Tuesday. At first glance, it looked official enough. It came in a white envelope with the Willow Ridge HOA logo stamped across the top. I assumed it was another newsletter about landscaping rules or neighborhood events. It wasn't. According to the letter, my tractor constituted a visual nuisance and a violation of community standards. The HOA demanded that I remove it from site within 7 days. I read the letter twice, then a third time. What caught my attention wasn't the demand, it was the wording. The letter never actually claimed my property was inside the HOA. Instead, it referred to my land as a community-adjacent parcel subject to neighborhood impact review. I'd spent years working county maintenance jobs. I wasn't a lawyer, but I knew enough to recognize language that sounded important without actually meaning much. I folded the letter and set it aside. 3 days later, another one arrived. This time there was a fine attached, then another, then another. The amounts weren't huge, but that wasn't the point. Someone wanted a paper trail. Someone wanted to create the appearance that they had authority over me. A week later, I ran into Marla near the subdivision entrance. Several residents were standing nearby, talking after a community yard sale. The moment she saw me, she smiled. Not a friendly smile. The kind of smile people wear when they think they're winning. "Have you made arrangements for that tractor yet?" she asked loudly. Several people turned toward us. "No," I said. Her smile widened. "Then I hope you're prepared for the consequences." I took a sip of coffee. "What consequences?" "The community has standards. My property isn't in your community." A few neighbors exchanged looks. Marla crossed her arms. "People like you always say that." The sentence hung in the air. People like you. Not landowners. Not neighbors. People like you. Then she pointed toward my property. "That tractor is lowering everyone's property values." I glanced at the group around us. Most looked uncomfortable. A few looked embarrassed. I simply nodded. "If that's true, you should probably have evidence." Her face tightened. She clearly expected an argument. Instead, I walked away. That seemed to irritate her more than anything I could have said. Over the next 2 weeks, things became stranger. More letters arrived. More threats. More references to violations that didn't actually cite any county code. Then one afternoon, I noticed survey flags near the old farm lane. Bright orange markers. Freshly installed. They weren't on my property, but they were close enough to get my attention. The next day, a contractor truck appeared, not near the subdivision entrance. Near the lane, the driver spent nearly an hour measuring distances and taking notes. When I approached him, he looked surprised. "I thought the HOA already owned access back here," he said. That statement stopped me cold. "Who told you that?" "The HOA office." He pointed toward the lane. "They said there's a future improvement project planned." A future improvement project. Suddenly, Marla's obsession with the tractor made a lot more sense. She wasn't trying to get rid of old machinery. She was trying to clear the path to something else. And for the first time, I began to suspect that the tractor was only the excuse. The land behind it was the real prize. The first letter arrived on a Tuesday. At first glance, it looked official enough. It came in a white envelope with the Willow Ridge HOA logo stamped across the top. I assumed it was another newsletter about landscaping rules or neighborhood events. It wasn't. According to the letter, my tractor constituted a visual nuisance and a violation of community standards. The HOA demanded that I remove it from site within 7 days. I read the letter twice, then a third time. What caught my attention wasn't the demand, it was the wording. The letter never actually claimed my property was inside the HOA. Instead, it referred to my land as a community-adjacent parcel subject to the Neighborhood Impact Review. I'd spent years working county maintenance jobs. I wasn't a lawyer, but I knew enough to recognize language that sounded important without actually meaning much. I folded the letter and set it aside. 3 days later, another one arrived. This time there was a fine attached, then another, then another. The amounts weren't huge, but that wasn't the point. Someone wanted a paper trail. Someone wanted to create the appearance that they had authority over me. A week later, I ran into Marla near the subdivision entrance. Several residents were standing nearby, talking after a community yard sale. The moment she saw me, she smiled. Not a friendly smile. The kind of smile people wear when they think they're winning. "Have you made arrangements for that tractor yet?" she asked loudly. Several people turned toward us. "No," I said. Her smile widened. "Then I hope you're prepared for the consequences." I took a sip of coffee. "What consequences?" "The community has standards. My property isn't in your community." A few neighbors exchanged looks. Marla crossed her arms. "People like you always say that." The sentence hung in the air. People like you. Not landowners. Not neighbors. People like you. Then she pointed toward my property. "That tractor is lowering everyone's property values." I glanced at the group around us. Most looked uncomfortable. A few looked embarrassed. I simply nodded. "If that's true, you should probably have evidence." Her face tightened. She clearly expected an argument. Instead, I walked away. That seemed to irritate her more than anything I could have said. Over the next 2 weeks, things became stranger. More letters arrived. More threats. More references to violations that didn't actually cite any county code. Then one afternoon, I noticed survey flags near the old farm lane. Bright orange markers. Freshly installed. They weren't on my property, but they were close enough to get my attention. The next day, a contractor truck appeared, not near the subdivision entrance, near the lane. The driver spent nearly an hour measuring distances and taking notes. When I approached him, he looked surprised. "I thought the HOA already owned access back here," he said. That statement stopped me cold. "Who told you that?" "The HOA office." He pointed toward the lane. "They said there's a future improvement project planned." A future improvement project. Suddenly, Marla's obsession with the tractor made a lot more sense. She wasn't trying to get rid of old machinery. She was trying to clear the path to something else. And for the first time, I began to suspect that the tractor was only the excuse. The land behind it was the real prize. The county records office sits in an old brick building just off the courthouse square. I'd been there before, during my years working county maintenance. But this visit felt different. This time, I wasn't looking for information. I was looking for answers. The woman behind the records counter introduced herself as Denise. After explaining the situation, I gave her my parcel number and asked for the property's historical filings. A few minutes later, she returned with a stack of documents thick enough to fill a binder. "Your family has owned this land a long time," she said. "Since my grandfather bought it." She smiled. "Looks like it." I spent nearly 2 hours going through the records. Most were exactly what I expected. Tax records, boundary updates, old surveys, agricultural filings. Then I found something interesting. A zoning certificate from nearly 30 years earlier. The paper was yellowed with age, but still perfectly readable. My father's name appeared across the top. I stared at it longer than I probably should have. Seeing his signature again felt like opening a time capsule. For a moment, I forgot about Marla, the HOA, and all the nonsense they'd created. Then I began reading more carefully. A sentence near the bottom immediately caught my attention. I read it once, then twice, then a third time. The wording stated that the Mercer parcel maintained grandfathered agricultural status and remained exempt from future private subdivision restrictions recorded after the filing date. Future private subdivision restrictions. I leaned back in my chair. That sounded important. Very important. I walked over to Denise's desk. What exactly does this mean? She adjusted her glasses and read the document. Then she looked at me. It means if a subdivision was created after this filing, those private covenants generally wouldn't automatically apply to your parcel. Even if my property borders the subdivision, correct. I thanked her and returned to the table. For the first time, I had something concrete, not proof of everything, but proof that Marla's authority might be built on assumptions rather than law. Then things became even more interesting. I requested the subdivision plats and GIS mapping records connected to Willow Ridge. A county mapping specialist helped pull them up. The digital maps revealed property lines, easements, drainage corridors, and setback requirements. At first, I focused on my own land. Everything looked normal. Then I zoomed in on Marla's property. The screen stayed silent for several seconds. The specialist frowned. That's odd. What is? He pointed toward a shaded section behind her house. A drainage easement. Then he pointed again. Directly over it sat a rectangular structure. Large. Recently constructed. Exactly where her pool house appeared to be. I felt my pulse quicken. Could the easement be wrong? The specialist shook his head. No. These maps are county recorded. He zoomed in further. The structure extended closer to the boundary than I expected. Close enough to raise questions about setback compliance. Close enough to attract zoning attention. I printed copies of everything. The zoning certificate, the parcel records, the GIS maps, the easement overlays. As I organized the documents into a folder, one thought kept repeating in my head. Marla had spent weeks trying to prove my tractor didn't belong where it sat. But if these records were accurate, her pool house might be sitting exactly where it wasn't supposed to be. And if that turned out to be true, she had made a very expensive mistake. Marla could have stopped. Looking back, that's probably what surprises me most. At several points, she could have walked away, admitted she overstepped, and avoided everything that happened next. Instead, she doubled down. 3 days after my visit to the county records office, a tow truck pulled into my driveway. I was standing inside the barn when I heard the diesel engine. By the time I stepped outside, the truck had already backed up toward my father's tractor. Marla was standing nearby with her arms crossed. 2 HOA board members stood beside her. Several neighbors had gathered to watch, almost like they had been invited. I walked toward the group. "What's going on?" I asked. Marla smiled. "The community has decided to remove the violation." I looked at the tow truck operator, then at the chain he was preparing. "You have paperwork for that," Marla answered before he could. "We've already handled the paperwork." I noticed she never actually said what paperwork. The tow driver looked uncomfortable. That told me everything I needed to know. I walked over to him. "Did anyone show you a court order?" He hesitated. "No." "A county citation?" "No." "Proof of ownership?" Another pause. "No." Marla stepped forward. "You don't need all that." The tow driver didn't look convinced. Neither did the neighbors watching from the roadside. Then Marla made a mistake. She ordered the driver to proceed anyway. The chain wrapped around the front of the tractor. Metal scraped against metal. The sound hit me harder than I expected, because the grill they were dragging against wasn't just a piece of machinery. My father and I repaired that grill together after a storm accident when I was 16. I could still remember him laughing when we painted it. Now I watched fresh scratches appear across it. For the first time during the entire conflict, I felt genuinely angry. Not loud angry. Quiet angry. The dangerous kind. I pulled out my phone and started recording. Then I looked directly at Marla. "You may want the county here before you continue." She laughed. Actually laughed. "Why, so you can complain about your tractor?" "No." I pointed toward her property. "So they can inspect everything." For a brief second, her confidence flickered. Only a second. Then it disappeared. "You don't know what you're talking about." Maybe. Maybe not. The tow driver finally stopped working and stepped back. "I'd rather have official authorization before I move anything." Marla was furious. She argued with him for nearly 10 minutes. He refused. Eventually, he climbed back into his truck and left. The neighbors drifted away, but the damage was already done. The tractor's grill had been bent and scratched, and more importantly, Marla had crossed a line. That evening I made copies of every document I'd collected: the zoning certificate, the county maps, the HOA letters, the emails, the videos. Then I called the county zoning office. I explained the situation and requested a formal inspection. Before ending the call, I added one final sentence. "You may want to bring the subdivision plat maps when you come." The woman on the phone paused. Then she said something that immediately caught my attention. "We were actually planning to." At that moment, I realized I wasn't the only person asking questions anymore. And when the zoning officer arrived, someone was going to have some very uncomfortable answers to provide. The zoning inspection took place the following Thursday. Word spread through Willow Ridge faster than I expected. By the time the county vehicle pulled into my driveway, several neighbors were already standing nearby, pretending they just happened to be outside. Nobody wanted to miss what they thought would be my downfall, especially Marla. She arrived 10 minutes early, confident, smiling, dressed like she was attending a board meeting instead of a county inspection. When the zoning officer stepped out of her vehicle, Marla immediately approached her. "Thank you for coming," she said. "We've been trying to resolve this tractor issue for months." The officer introduced herself as Dana Reeves. Then she surprised everyone. Instead of walking toward the tractor first, she asked a simple question. "Who owns this parcel?" "I do," I said. Dana nodded and opened her folder. "Mr. Mercer, I'd like to review a few documents." I handed her the folder I had prepared. The grandfathered zoning certificate sat on top. The recorded parcel filings were underneath. Marla folded her arms. I could practically see her waiting for Dana to declare victory on her behalf. Instead, Dana spent several minutes reading. Then she turned to me. "Do you have the original recording information for this filing?" "I do." I handed it over. She compared the numbers, checked the county database on her tablet, then checked them again. The silence grew uncomfortable. Finally, Dana looked up. "These records appear valid." Marla's smile disappeared. "What does that mean?" Dana answered without hesitation. "It means this parcel predates the subdivision restrictions." Marla blinked. "I don't understand." "It means the HOA does not automatically have authority over this property." The neighbors exchanged glances. A few quietly stepped closer. Dana continued reviewing the documents. Then she looked directly at Marla. "Do you have documentation showing this parcel falls under HOA control?" The question sounded simple, almost harmless, but I already knew how important it was. Marla hesitated, only briefly. I'm the HOA president. Dana remained expressionless. That wasn't my question. Marla shifted her weight. The property affects the community. Can you show me a recorded document granting HOA authority over this parcel? The silence that followed felt much longer than it probably was. For the first time since this entire conflict began, Marla didn't have an answer ready. One of the board members looked at her. Then another. Neither seemed particularly comfortable. Finally, Marla said, "Our attorney handles those things." Dana made a note on her clipboard. Then she asked another question. Was the tractor cited under county code or HOA guidelines? No response. Because everyone standing there suddenly realized the same thing. The HOA had spent weeks acting like it possessed authority that might not actually exist. Dana closed the folder. At this point, I see no zoning violation involving the tractor. Several neighbors exchanged surprised looks. One actually laughed under his breath. Marla looked furious, but Dana wasn't finished. She turned toward the rear section of the subdivision, toward the area where Marla's new pool house stood. Then she opened a second map, the county GIS map, the same one I had printed days earlier, and the next question she asked changed the atmosphere completely. "Mrs. Whitcomb," Dana said calmly, "can you show me the permit and setback approval for the pool house behind your property?" Marla's face went pale. For a moment, nobody said anything. The neighbors, the board members, even Marla. Everyone seemed to understand that the conversation had suddenly moved in a very different direction. Dana unfolded the county GIS map across the hood of her vehicle. The paper fluttered slightly in the afternoon breeze. "Mrs. Whitcomb," she repeated. "Do you have the permit file for the pool house?" Marla cleared her throat. "My contractor handled that." Dana nodded. "Then you should have copies." Another silence. The confidence Marla had arrived with was disappearing fast. One of the board members stepped closer. "Is there a problem?" he asked. Dana pointed to the map. "This shaded section is a recorded drainage easement." Her finger moved across the page, then stopped directly beneath the outline of the structure behind Marla's home. "The pool house appears to overlap this easement." The board member frowned. "How much?" Dana looked at the measurements. "Enough that we need to investigate." Marla immediately shook her head. "That's impossible." I had heard that phrase before, usually right before someone discovered the county records didn't care about personal opinions. Dana remained calm. "Do you have an approved easement encroachment authorization?" "No." "A variance?" "No." "A recorded exception?" Marla didn't answer, because she couldn't. The questions were becoming increasingly specific, and every answer seemed to lead toward the same conclusion. One of the neighbors finally spoke up. "Wait a minute. Is the building actually legal?" Dana chose her words carefully. "I haven't completed my review yet." Then she opened another folder, the subdivision plat maps, the same maps the county had mentioned when I called. She compared several measurements, made a few notes, then looked directly at Marla. "The structure also appears to violate rear setback requirements." The reaction was immediate. Two board members began asking questions at once. Another neighbor pulled out a phone and started recording. Suddenly, the inspection that was supposed to target my tractor had become a public examination of Marla's property. But the biggest moment came a few minutes later. I reached into my folder and removed a printed email. The accidental email. The one discussing the pool house expansion and the future access corridor. "Dana," I said, "you may want to see this." She read it carefully, then read it again. The phrase "future community access corridor" immediately caught her attention. "What is this referring to?" she asked. No one answered. I wasn't surprised, because everyone already knew. The HOA's real interest had never been my tractor. The tractor had simply been standing between them and the project they wanted. Dana looked toward the old farm lane, then back toward Marla. You were planning additional development. Marla hesitated. It was only a concept. One of the board members stared at her. A concept funded with HOA money. That question hit harder than anything I could have said. Several residents exchanged shocked looks. They clearly hadn't heard about the project either. Dana slowly closed the folder. Then she reached into her vehicle and pulled out a bright red document envelope. The color alone seemed to drain the remaining confidence from Marla's face, because everyone standing there knew exactly what was about to happen. And this time, there was no tractor left to blame. Dana didn't raise her voice. She didn't need to. The red notice in her hand did all the talking. In front of nearly a dozen residents, 2 HOA board members, and Marla herself, she attached the county violation notice to the inspection file and began explaining the next steps. The pool house is now under formal review, she said, effective immediately. All expansion work must stop. Nobody moved. Nobody interrupted. The only sound came from a construction crew in the distance, slowly shutting down equipment after receiving instructions from the county. Marla looked stunned. This is ridiculous. Dana didn't react. You'll have an opportunity to respond through the proper process. But the tractor is not in violation. That sentence landed like a hammer. Weeks of complaints, threats, letters, fines, meetings, public accusations. All of it had led to this moment, and the county had officially confirmed what I'd been saying from the beginning. The neighbors weren't looking at me anymore. They were looking at Marla. The change was impossible to miss. People who had quietly supported her were suddenly asking uncomfortable questions. One resident stepped forward. How much HOA money was spent on that project? Another followed. Why didn't the board know about the easement issue? A third asked the question Marla seemed least prepared to answer. When were homeowners going to be told about the access corridor? Silence. Again. The same silence that appeared whenever facts replaced assumptions. The emergency HOA meeting took place 3 nights later. Attendance was the highest the subdivision had ever seen. I wasn't a member, but several residents later told me what happened. The meeting lasted nearly 4 hours. By the end of it, financial records had been requested. Project communications were reviewed. The email chain involving the pool house expansion became a major topic of discussion. So did the attempt to pressure me into giving up access near the farm lane. Residents learned that preliminary planning had already consumed HOA funds, money that many homeowners never knew was being spent. People were angry, not because the project failed, because they had been kept in the dark. Within 2 weeks, Marla resigned as HOA president. Officially, she described it as a personal decision. Nobody believed that. The county investigation continued. The stop work order remained active. Additional reviews were scheduled regarding the easement encroachment. Meanwhile, something much simpler happened on my property. A certified check arrived. It covered the damage caused to my tractor's grill. Apparently, the HOA's insurance carrier preferred settling that issue quickly. I accepted reimbursement for the repair. Nothing more. No bonus payment. No silence agreement. No settlement demand. Just the cost of fixing what had been damaged. A few neighbors later asked if I felt satisfied. Honestly, satisfaction wasn't the right word. Relief was closer. Because for months, I'd been treated like the problem. Now the truth was finally sitting where everyone could see it. And while the county handled the rest, I had something more important to do. I still needed to repair my father's tractor. 6 months later, Willow Ridge looked very different. The biggest change wasn't the landscaping. It wasn't the entrance sign. And it certainly wasn't my tractor. The biggest change was that people had started paying attention to paperwork. The county eventually completed its review of the pool house project. The final decision required significant modifications to the structure and restoration work within the drainage easement area. Construction crews returned more than once, not to build, to remove. Sections of the project were dismantled. Landscaping was altered. Several improvements that had once seemed permanent suddenly disappeared. The proposed access corridor project vanished completely. No more discussions. No more survey flags. No more contractors measuring land they didn't own. The HOA quietly removed every reference to it. A few months after that, new board members were elected. From what I heard, the first thing they did was hire an outside consultant to review procedures and spending practices. Apparently, people had developed a new appreciation for transparency. As for me, I stayed busy with simpler things. One Saturday morning, I rolled the tractor into the workshop. The replacement parts had arrived weeks earlier. I just hadn't felt any urgency. The machine had survived storms, decades of work, and more than one stubborn owner. A few scratches weren't going to change that. Still, repairing it felt important, not because of the damage itself, because of what the tractor represented. I spent most of the afternoon straightening the grill, cleaning old metal, touching up faded paint, the same way my father and I had done years before. At one point, I opened his old toolbox. The wooden handle was worn smooth from decades of use. For a moment, I simply stood there, holding it, thinking, remembering. The legal fight had never really been about a tractor, and it had never been about a pool house either. It was about boundaries, not fences, not property lines, respect, the kind that comes from understanding that ownership matters, that records matter, that patience matters. Too many people assume the loudest person in the room has the most power. What I learned is that real power often sits quietly inside a filing cabinet at the county records office, waiting for someone to read it. Late that evening, after the repairs were finished, I drove the tractor slowly across the pasture. The engine sounded exactly the way I remembered. Steady, reliable, familiar. The sun was setting behind the trees when I parked beside the barn. For the first time in months, everything felt peaceful again. The farm lane remained untouched. The property remained mine. The tractor remained exactly where it belonged, and so did the truth. Because in the end, Marla had spent months trying to prove that my father's tractor didn't belong there. The county records proved something much simpler. It always had. If you've made it all the way to the end of this story, thank you for spending your time with me. I'd love to hear what you think. If you were in my position, would you have handled things the same way? Or would you have taken a different approach? Let me know in the comments. And tell us where you're watching from and what time it is in your part of the world. It's always fascinating to see how far these stories travel. If you enjoy property rights stories, HOA conflicts, and real-world lessons about patience, paperwork, and standing your ground without losing your dignity, please consider liking the video and subscribing to the channel. Until next time, take care of the things that matter, keep good records, and never underestimate the value of knowing exactly what you own.